Can you hear me?
Yes.
I sent you an email. Don't know whether you've seen it. It's about the question that I was asked.
I'll have a look.
Okay, sure, thanks.
Hi, James. Did you also send me that email?
Sorry, no, I didn't. I should have done. I was just essentially asking whether I can answer Lord Justice Nugee's question without having to go into private, basically.
Probably then less for me, but it probably still sounds good for me to.
No, you're quite right.
Have a copy.
Sorry, Mark, I don't know what the question is.
Yeah, I'm going to send it through to you. Sorry.
We seem to be all reconvened. If you're ready, Mr. Segan.
Thank you, my lord. Before the short adjournment, your lordship asked me whether I could answer your lordship's question about whether there was an offer from Vestel related to UK patents alone,
Yes.
without going into private. I've raised that with my learned friend, but we haven't reached a landing on that yet. So I should defer the issue for now and come back to it as and when.
Yes.
We were on Gateway 11, the UK property gateway, and I had shown you what the judge said about that at paragraph 115, specifically that the new paragraph 93A in the pleading was just an alternative way of inviting the court to settle a global license. And there are just a few references I would like to show the court to make that good. You may have seen or picked up already that it's actually in paragraph 93A itself. So core tab 15, page 169. There's a section just after the two declarations in brackets, which says, for the avoidance of doubt, it is Vestel's case that the license terms which would be found for a license for the patents which designate the United Kingdom would be the terms of a global license. That's the whole rule, and Mr. Chatsfield repeated that point yesterday. And then if one picks up the supplemental bundle at tab 5, there is Mr. Moss's evidence in support of the application for permission to serve out, and that page, let me just have a look, paragraph 22, page 22 of the bundle. Last sentence of paragraph 22 of Mr. Moss. He said it's the claimant's case that in order to resolve the issue inter alia of the FRAN terms relating to the UK patents which form part of the HEVC portfolio, the court will of necessity have to determine the FRAN license terms on a global basis. In paragraph 27C on page 25, Mr. Moss said, third, for the reasons stated above, the claim in effect relates to a global FRAN license. In relation to Gateway 11, if we just turn back a page, page 23, you will see in paragraph 24B, when addressing that gateway, Mr. Moss said, Vestel's claims for declarations in respect of FRAN terms upon which HEVCA is obliged to license the patents relate to property within the UK. Now, of course, what that statement of the gateway missed out was the words wholly or principally, and we pointed that out in our reply evidence. Well, it's perhaps worth seeing 30D as well, page 26. Paragraph 30D, Mr. Moss said, the claims relate inter alia to property situated in the jurisdiction namely the patents which designate the United Kingdom. And we pointed out that the gateway had not been accurately stated. There was then further evidence from Mr. Jones, which is supplemental tab 7, page 46, paragraph 37C, page 46 of the bundle, paragraph 37C. Mr. Jones says, Gateway 11, Mr. Edson is quite right. Gateway 11 requires the subject matter of the claim to relate wholly or principally to property within the jurisdiction, as set out above and in paragraph 24B of MOS 1. Vestel's claim clearly relates to property within the jurisdiction, namely EPs designating or validated in the UK. Then skipping a sentence, I would note in passing that Gateway 9 does not contain any qualifications similar to that in Gateway 11. So Mr. Jones again misses out in the second sentence of that paragraph the words wholly or principally. And then in the skeleton argument for the hearing before His Honour Judge Hacon, tab 23, page 191 of this same bundle, in paragraph 49, Vestel said, as to whether the proceedings relate wholly or primarily to such property, now that should be principally. As explained in the evidence of Mr. Moss and Mr. Jones, all of the EP patents within the HEVCA portfolio designate the UK. Whilst the pool is a worldwide patent pool, it is the European patents within the portfolio which are of particular relevance to Vestel, given the nature of its business, which is centred upon Europe. Further, so far as the second claim is concerned, it's the UK patents which primarily concern it, given it operates in the UK. And then at paragraph 55 on page 193, there's reference to the objection about a lack of authority to grant a UK licence. And in the fourth line, it said, this objection is misplaced, however, because, as explained above, it's Vestel's case that the licence which would be granted for the UK patents in question is a global licence. There's reference to the willing licence or licensee test. So paragraph 93 is quite explicitly simply a way of dressing up a claim which relates avowedly to all of the patents in the HEVC patent pool. My learned friend wishes to seek a declaration as to FRAND licensing terms for all of the patents in the pool. Now, that brings me at that point to the attempted analogy with the Unwired Planet and Conversant cases.
Just before you do that, suppose it were the facts, which are not quite our facts, but they're not that remote, that the only televisions which were sold, which needed the patent license, were sold in the UK. So that the only concern that Vestel had was patent infringement in the UK. And otherwise, it was as it is. In order to meet the allegation of patent infringement, it wants a license. It wants its license to be on FRAND terms. It says its FRAND terms are global terms, so it would have to have a global license. But all it's actually interested in is the position in the UK. Now, in those circumstances, the license would relate to patents around the globe, of only 2.5% of which would be UK patents. But all Vestel really wants is protection against infringement allegations in the UK. Would that make it a claim that was related wholly or principally to property in the UK?
No, in my submission. One has to look at the property in respect of which the declaration is being sought. And if it remained the case that despite the fact that from a commercial perspective they only ever wish to have a license in the UK, your lordship's hypothetical TV manufacturer were nevertheless seeking a declaration in respect of the terms of a license relating to the entire global pool, then it would no longer be a claim which related wholly or principally to property in the UK. And I emphasise here that because it's true, of course, and I'm going to come to it, Unwired Planet and Conversant discuss the common practice of global licensing. But the question here for us is, does the particular declaratory claim formulated in this case pass through the gateway? And this particular gateway. This particular gateway says the claim has to relate wholly or principally to property in the UK. And as soon as one is asking for a declaration as to the FRAND licensing terms for a whole pool of global patents, in my submission, it becomes impossible to say that the claim relates wholly or principally to UK property. And that's where I come to the distinction, if I may, with Unwired Planet and Conversant, because the analogy doesn't work, because the basis for UK jurisdiction in those cases was an extant claim for infringement of UK patents, in which FRAND was raised as a contractual defence. And
just wasn't an issue.
Well, it was before Mr. Justice Henry Carr, but it was resolved, I'll show you in a moment, it was resolved on the basis this is a claim for infringement of 4 UK patents. It was then not in issue in the Court of Appeal, and it was not in issue in the Supreme Court, but their analysis of the forum conveniens issue, just to foreshadow where I'm going to get, was that the reason that the UK was an appropriate forum in those cases was these are claims for infringement of 4 and 6 UK patents respectively, in which a contractual defence has been raised. So let me just show you the 3 decisions. First of all, the High Court, Mr. Justice Henry Carr, is Volume 2, Tab 21. As I say, these were claims by Conversant against Huawei for the infringement of 4 UK patents. And if we go to paragraph 65, we can pick up that point in particular. Well, actually, let me just show you to make the point I made just now. Paragraph 7, page 632. On 24th of July 2017, Conversant commenced these proceedings, claiming that the defendants were infringing the UK designation of 4 of its European patents. Now, we then go forward to paragraph 65, and one can see what Huawei's, or rather how the court dealt with the issue. Paragraph 65, page 645. In my judgment, the characterisation of these claims as foreign portfolio infringement claims or worldwide royalty claims is inaccurate. They are claims for the infringement of 4 United Kingdom patents, and the English court is clearly the appropriate forum in which these cases should be tried. 66, the fact that these are claims for infringement of UK patents is a matter of substance, not form. I don't know whether it is just my screen, but I can't any longer see my Lord Justice Nugee.
It's also me.
I shall stop there.
I think he may have dropped off. His name doesn't appear in the participant list. We've got to just wait.
I'm sorry, Mr. Segan, I dropped out of the meeting for a couple of minutes.
Not
I was on
at all,
paragraph 65 when I
Yes.
heard you.
Indeed. The second line, they are claims for infringement of 4 United Kingdom patents, and the English court is clearly the appropriate forum in which cases should be tried. Similarly, paragraph 66, the fact that these are claims for infringement of UK patents is a matter of substance, not form. Paragraph 68, I agree with Mr. Justice Birss that there's no such thing as a portfolio right. That mischaracterises the claim, as it is not the cause of action sued upon. These claims are concerned with infringement of UK patents, and the relief should be granted if infringement is established. And then we have the consequence in 69, if the forum convenience argument were accepted. In the fourth line, Mr. Justice Henry Carr says, if these claims were stayed on the basis of forum non-convenience, then the consequence would be that the English court could not decide upon infringement of UK patents and could not decide what relief it would be appropriate to grant where such patents are infringed. That, in my judgment, would not be in the interests of all the parties and in the ends of justice. And there's a reference to the Harman fallacy, and in the last sentence of 70, the defendants focus solely on the relief claim and therefore ignore the substance of the claim for infringement of UK patents. So it's very clear that the hook, the jurisdictional hook, is that this is a claim for infringement of 4 UK patents. The same point is in 73, fourth line. Third line, this does not mean that China is the natural forum for a case which concerns allegations of infringement of UK patents and for relief in terms of a global FRAND license. So the characterization of the claim is important and is said to be a matter of substance. One then gets to Gateway 11 at page 653, paragraph 108. Mr. Justice Henry Carr sets out the gateway and says the 4 patents sued upon in these proceedings as EP patents designating the UK constitute property within the UK within the meaning of Gateway 11, since they are UK intellectual property. I do not accept the defendant's argument that claims do not relate principally to the UK patents, but rather to foreign patents. And then there's a reference to tangible or intangible property. That's not a point that arises here. And then in 110, I conclude that the subject matter of the claims relates wholly or principally to property within the jurisdiction and that the requirements of Gateway 11 are satisfied. So the analysis here is these are infringement claims in respect of 4 patents.
Why was it not simply brought under Gateway 9 as being a claim based on tort, the tort being infringement of a patent, where the harm would take place in the UK?
Off the top of my head, my lord, I can't answer that question.
You can see that 5 gateways were relied on, but only 2 were dealt with in the learned judge's judgment.
Yes.
So it's possible that one of the others was mentioned too.
Yes. It's a fair question. I'm sure someone will supply me with the answer, but off the top of my head, I don't know. But at any rate, as regards 11, the analysis is very clear. The matter then went to the Court of Appeal, tab 24 of the same bundle. And there was no appeal in respect of the gateways. So this is paragraph 18 on page 95 of the judgment of Lord Justice Floyd for the court. And one can see in paragraph 18, 6 lines up from the end of the paragraph. Secondly, and he's describing here Mr. Justice Henry Carr, the judge held that the claim fell within Gateway 11. This was on the basis that the 4 patents sued upon in these proceedings as European patents designating the UK constituted property within the UK within the meaning of Gateway 11, since they're UK intellectual property. There is no appeal. But just on the question of how one characterises these issues, it's worth looking at some of the reasoning on forum non-convenience, because the same point is made. Paragraph 104 on page 104 under the heading Forum Non-Conveniens on the basis of the judge's characterisation of the claim, Lord Justice Floyd says again, if one characterises the case in the way in which the judge characterised it, with which I agree, then it seems to me the Forum Conveniens question answers itself. The fact that the dispute concerns UK patents is a matter of substance and not form. The matter then went to the Supreme Court, which is in the next volume of authorities at tab 27. And in the Supreme Court, the analysis that FRAND is a contractual modification to the general law of patents was made particularly strongly. So in tab 27, page 2433 of the report, paragraph 14 thereof, in the judgment of the court, they looked very closely at the EWCA IPR policy over the preceding paragraphs, and they said, it appears from this brief review of the IPR policy in its context that the following conclusions may be reached. First, the contractual modifications to the general law of patents are designed to achieve a fair balance, etc. Secondly, the SEP owner's undertaking, which the implementer can enforce to grant a license to an implementer on FRAND terms, is a contractual derogation from a SEP owner's right under the general law to obtain an injunction to prevent infringement of its patent. And then skipping further down the paragraph in the context of the fourth point, which begins next to G, there's a sentence, under the general law of the jurisdiction governing the relevant patent rights is to request a license from the SEP owner by enforcing that contractual obligation on the SEP owner. So the analysis is pretty clear as to what the structure is. Mr. Pickford already showed you paragraph 58, which is important and makes the precise point that I'm making, that what gives the UK courts the jurisdiction is the assertion of UK patents. And then there's the contractual defence. And it's the UK patents that are the hook. Then paragraph 90, page 2454. There's a reference to they're considering here the first issue, the global issue. Next to letter F, paragraph 90, referring to the policies, those policies which either expressly or by implication provide for the possibility of FRAND worldwide licenses when a SEP owner has a sufficiently large and geographically diverse portfolio and the implementer is active globally, do not provide for any international tribunal or forum to determine the terms of such licenses. Absent such tribunal, it falls to national courts, before which the infringement of a national patent is asserted, to determine the terms of a FRAND license. And then over the page at 2455, they turn to forum non-conveniens. And in 93, they say that the issue necessarily proceeds upon the assumption with which we agree that, contrary to the appellant's main case, the English court has jurisdiction to settle a global license on FRAND terms for a multinational SEP portfolio. This is mainly because issues as to a global license need to be determined to enable the court to adjudicate upon a contractual defence to the enforcement of an English patent by injunction. Then in 95, they come to the question of how to characterise the dispute. And in the third line, they say, is it as the appellant say in substance a dispute about the terms of a global FRAND licence, or is it as the respondent maintains both in form and in substance, about the vindication of the rights inherent in English patents, and therefore about their validity and infringement, with FRAND issues arising only as an aspect of an alleged contractual defence. And then further on down the paragraph next to E, at the heart of the analysis which has thus far prevailed is the recognition that the owner of a portfolio of patents granted by different countries is in principle entitled to decide which patents, and therefore in which country or countries, to seek to enforce, and cannot be compelled to enforce patents in the portfolio granted by other countries merely because a common FRAND defence to the enforcement of any of them raises issues which might more conveniently be determined in another jurisdiction than that which exclusively regulated the enforcement of the chosen patents. Were it necessary to choose, we would have agreed with the choice made by the court below. So, in my submission, the Supreme Court was absolutely clear that the reason it was permissible to determine a global FRAND licence was that the UK courts had been seized of a claim over which they indubitably had jurisdiction, a tort claim for infringement of UK patents, and then the implementer invoked a contractual defence, which required the court to determine the terms of a FRAND licence for the whole portfolio. So even if this were a properly formulated contractual claim for a preemptive declaration as to what the terms of a global FRAND licence might be, and I emphasise it is not, but even if it were, it would not follow in my submission from anything said in Conversant that such a claim would fit through Gateway 11. The basis for finding that Gateway 11 was satisfied in that case was that it was a claim about for infringement of 4 UK patents. Now, my learned friend also referred extensively to the Unwired Planet case, which of course was the conjoined appeal in the Supreme Court, but that, in my submission, doesn't add anything to Conversant, because again, that was an infringement action based on 6 UK patents in which FRAND was advanced as a contractual defence. And in fact, as Mr. Chatfield recognised yesterday, there wasn't a challenge to the international jurisdiction of the English courts in that case at all. So we say nothing in Conversant or Unwired Planet supports my learned friend's submission that his proposed declaratory claim passes through Gateway 11 at all. And applying the words of that gateway, a claim for a declaration as to FRAND terms, which is avowedly intended to encompass a global pool of patents, only 2.43% of which are UK patents, cannot possibly be described as a claim concerned wholly or principally with UK property. My lords, my lady, I turn now to the necessary or proper party gateway. My learned friend said very little about that, and so I simply rely on what I say in paragraph 39 of our skeleton, that we don't accept that Advance has to be a necessary or proper party to any claim against Philips, but in our submission, there's no jurisdiction against Philips either. That's the necessary or proper party gateway. Then one comes to the same or closely connected facts gateway. I don't know really where we are on this, because in my skeleton at paragraphs 41 to 42, I recorded that it wasn't clear what further claim my learned friend actually had in mind in relying on this gateway. So 41 to 42, it's tab 7 of the core bundle, page 71. We submitted Vestel does not explain what further claim, to use the language of Gateway 4A, it is referring to here, and then we recite what the evidence and skeleton said. And there wasn't any explanation of that. My learned friend's only submission was to say, I do not detect any argument that means that Gateway 4A will arise, but that he would reserve his position pending what Mr. Pickford and I had said. So it being for Vestel to make out a case under the gateway, it not having done so, I submit that it's plainly not satisfied. So, in short, the court was absolutely right to find that this claim, albeit it bore an entirely different shape below, did not fit through the gateways. That's the first requirement. The second thing that Vestel needs succeed in obtaining permission to serve out is that there is a reasonable prospect of success in its claim. And in paragraphs 45 and 46 of my skeleton, I identified two reasons why we say that that is not met. The first is that the courts only grant declarations which are concerned with the existence or scope of legal rights, public or private, and that there are simply no such legal rights pleaded here. Just to be clear, that's the same point, or I intend it to be the same point, as I make at paragraph 6.2.1 of the skeleton, i.e. the need for some kind of pleaded legal standard according to which the claim can be judged. When taxed with this issue, Mr. Chatsfield ultimately submitted, by reference to the Pfizer case, that the courts can grant declarations which are wholly untethered to any legal issue or standard, and that the only constraint is the useful purpose criterion. We say, with all respect, that can't possibly be right in principle, even before one comes to the authorities, and we say it's not the correct reading of Pfizer. To start with some absurd examples, Mr. Pickford's already given his best barrister example. It might conceivably serve a useful purpose for the court to declare which of Mozart's piano concertos was the greatest, or whether Manchester United or Manchester City are the greatest football team. It doesn't mean that the court will do any of those things. Why? Because the debates are not tethered to a legal standard. You might say to me, those are deliberately absurd examples. We're talking here about what's fair, what's reasonable, and what's non-discriminatory. Aren't these just easily cognizable judicial concepts? Well, the answer is that those concepts, of course, take their precise meaning from the legal context in which they are said to arise. Mr. Pickford has already given you the example of non-discrimination, which is a very pertinent example. The Supreme Court's decision in relation to non-discrimination in Unwired was explicitly based on the interpretation of non-discriminatory friend obligation. And I won't take you back to it, but it's worth noting that one of the big points that featured with the Supreme Court, it's paragraphs 116 to 119, was the travaux préparatoire of the HEVC obligation. Because their point was it had expressly been raised by the adopters of the HEVC IPR policy that whether there should be a most favoured nation clause in effect, and that proposal had been rejected. And the Supreme Court said that was a very powerful and important point in adopting the interpretation of non-discriminatory that they did adopt. Now, I have no idea whether the same could be said of the ITU and ISO policy, or whether in that context it may have been some other factor that played a more important role. And of course, the same is true of fairness and reasonableness, because they come up in an enormous number of different ways in private and public law. In fairness and reasonableness, there's under UCTA 1977, there's a whole schedule to the Act on how to apply a reasonableness test under that Act. It's a very important concept in the common law on tort. If we're in the public law domain, then fairness might be by reference to the standards of procedural fairness. Reasonableness is not a ground of challenge in and of itself, but it's sometimes been used as a shorthand for irrationality. There was a whole Supreme Court case in Gallagher about whether there's a freestanding equal treatment principle in public law. One can't debate the requirements of terms like fairness, reasonableness, or non-discrimination in the abstract. You have to have a standard according to which one judges the issue. Now, what that then leaves is my learned friend's reliance on Pfizer, but my submission, he's not read the case correctly. It's volume 2, tab 25. The first point to make is that, of course, this was not a case about international jurisdiction, but at any rate, the principles were set out by my Lord Justice Birss in paragraphs 61 onwards. And the important passage I wanted to take you to, because I don't think Mr. Chatsfield did, is paragraph 66 onwards, page 391. Paragraph 66 refers to the fact that each side cites a lot of cases, etc. Third line, there are few decisions which stand for any relevant overarching principles. Accordingly, I'll not go through all of the cited cases, but focus only on what I believe are the most important ones. And then my lord goes through the most important appellate authorities and summarises them in paragraph 74 as follows. In my judgment, the decisions above were all concerned with the existence or scope of legal rights, public or private. And then Milebush, Rolls-Royce, Messier, Gourier, and FSA and Rourke are described. Paragraphs 75 and 76 make the point that it could be an issue of fact, but which is tethered to a legal issue, and the example given is a boundary dispute, and that must be right. But the last sentence of 76 makes clear, nevertheless, while that can be portrayed as a matter of fact, it comes to court because it's concerned with the existence or scope of a legal right. So in my submission, this authority makes clear that the authorities require some kind of connection to a legal right or standard. It certainly doesn't support the submission that the only test is useful purpose, and it doesn't matter whether there's a legal standard at all. My lord in that case mentioned the Gourier case. There's a very well-known citation from Lord Diplock in Gourier, which can be found in the Office Depot case that my learned friend took you to earlier today, tab 22 of the same bundle, in paragraph 74. Sorry, not paragraph 74, 47. Mrs. Justice O'Farrell gives the relevant citation from Gourier, Lord Diplock. The only kinds of rights with which courts of justice are concerned are legal rights, and a court of civil jurisdiction is concerned with legal rights only when the aid of the court is invoked by one party claiming a right against another, etc. And the court has the point that if one looks at the pleading, that's not this case. So that's the first point on reasonable prospect of success. The second point we make is that a pure declaratory action would serve no useful purpose. And it's common ground that useful purpose is the test here. And there is a strong overlap with forum non-convenience, because as the Supreme Court made clear in the Unwired case, there's an established process for dealing with these sorts of FRAND issues. As we've seen, there are technical or commercial negotiations, and if those cannot resolve the matter, then the patentee will bring infringement proceedings, and FRAND issues will be decided in that context. The question in the present case is whether it would serve a useful purpose for the English courts to seize themselves of declaratory proceedings, despite the fact that there are no underlying infringement proceedings. Mr. Chatfield said that that he had 7 reasons for doing so, but to address them in turn, we say none of them holds water. The first 2 points were that the UK is a large market for Vestel. Now, we of course accept that, but that doesn't in itself establish that it would serve a useful purpose for the English court to embark upon the exercise Vestel is proposing, in preference to some other court before which infringement is actually asserted. The third point was that 77 patent families designate the UK, but the basic fact is that less than 2.5% of the patents in the pool are UK patents. The fourth point was that Vestel had been threatened with proceedings, but that ignores the point that Vestel has never said that it has been threatened with proceedings in the UK, nor has it pointed to any document in which any such threat has been made. On the contrary, the only letter it relies upon mentioning an injunction that come from German lawyers. The fifth point was that these proceedings would inform Vestel about its exposure, but so too would proceedings in whichever jurisdiction heard an infringement action, in this case Germany. The sixth point was that the declarations would serve as a bar to any action in the UK because of clause 4.1 of the agreement among licensors. Now, my learned friend accepted that Vestel itself has no rights under that agreement. How it might operate would depend on the precise facts and the grounds of any judgment that was delivered. But in any event, even if correct, that point does not indicate that proceedings in the UK, as opposed to anywhere else, serve a useful purpose, which is, in my submission, the relevant issue here. Now, Mr. Chatsfield's seventh point was spin-off value. Now, he positioned this as the last point, but it's actually the critical issue because these proceedings have always been intended to forestall, if possible, other sets of proceedings. And we can see this, for instance, in the supplemental bundle at tab 23. This is the skeleton argument for the hearing below. And at page 184, one sees in paragraph 21, there's a description of the position by late 2018. The parties have reached an impasse. Third line, Vestel, for its part, was concerned that it might be faced with an injunction claim, which HEVC had already threatened as outlined above, in a jurisdiction where the court may be prepared to grant an injunction without any determination of whether the licensor's offer is substantively frowned. Now, just pausing there, that was the topic, of course, as you would have seen from the judgment, that actually formed a large part of the debate before His Honour Judge Hacon, because the primary theory on loss and damage was that there was some court somewhere that would compel Vestel not only into non-FRAND terms, but indeed abusively high terms. And His Honour Judge Hacon found that there was no evidence that there was such a cause. But the importance for present purposes is that it is the apprehension of proceedings in another jurisdiction that seems to have led to these proceedings, because one sees in paragraph 22, in the circumstances set out above, Vestel therefore brought these proceedings in this jurisdiction in early 2019. Now, insofar as my learned friends identified a court, they said the German court, and that is, one sees that in the evidence of Mr. Jones in the same bundle at tab 8. Page 50, paragraph 11, there was reference to the mass Elektronik litigation in the Düsseldorf District Court. And it goes on over paragraphs 11, 12, 13, and Mr. Jones says, in summary, in 14, it appears that 4 licensors within the HEVCA pool have commenced actions against a third party, A in the same court, B at about the same time, C in respect of patents in the pool, and D using the same firm of lawyers. And what is more, the point about Germany derives some support also from the grounds of appeal. In this case, core bundle tab 2, page 12, paragraph 7. The learned judge had no basis to hold, or was wrong to hold, that other courts in the EU would probably settle FRAND terms. The judge overlooked the evidence of injunctions being sought in Germany. Now, in relation to this issue of spin-off value, in paragraph 46 of my skeleton, I summarise the points that we rely upon in this regard, and I shall just develop each of them. So the first is that there's no evidence of spin-off value. Now, for this purpose, I need to go back to Pfizer, which is volume 2, tab 25. It won't take very long, because the simple point is that in that case, there was extensive evidence and consideration of whether there would be any spin-off value in an English judgment. And in paragraphs 20 to 21, which are page 383 of tab 25 in Authorities 2, there was reference to the fact that both parties had called experts on Belgian law in 22-21, and one then sees that evidence considered in great detail from 89 onwards under the heading Belgian law, page 396. Especially under the heading on the page 398, likely impact of a UK decision in Belgium, paragraph 97 through to 107. So there was particularly careful scrutiny of claims based on alleged spin-off value, but here there is no evidence on spin-off value at all. Germany is not, to put it in the language of Vestel's skeleton, it is not a jurisdiction which grants injunctions before considering whether patentee's offer is found. Indeed, that's a point I needn't take you to. It's actually a point that the Supreme Court itself made in Unwired Planet at paragraph 77. But the best way that one can see it is from the mass electronic litigation that Vestel had itself referred to in its evidence before His Honour Judge Hacon, and that is in Authorities Volume 3, tab 32. So this is the litigation that Vestel said caused it concern. This was a successful infringement action by Dolby, one of the HEVC advanced pool members, against Mass Electronic for infringement of one of the steps in the pool. There were other proceedings by Philips and others reported under different case numbers. Mass relied on a Fran defence, contending that there should be no injunction because the licenses were based on the advanced PPL, which was said not to be Fran. And the court dealt with the issue at some length. And I can only really just highlight some of the relevant passages. So at page 10, the court went in some detail into the history of the HEVC standard, the respective pools, and the such like. On pages 12 onwards, it set out all the royalty rates that are impugned by Vestel. There's reference on page 15 at the bottom of the page to the white paper that I was telling you about earlier. An explanation of the royalty rates can be found in the white paper produced by HEVC Advance, which can be requested via the HE Advance website, etc. One then goes forward to 22. You can see where the argument of Mass Electronic is substantiated or is set out. Page 22, next to the first hole punch. As substantiation for its antitrust defence of compulsory licensing, the defendant argues that the licensing agreement offered to it is neither fair nor reasonable. Furthermore, it is treated unequally by the side agreements. The royalty rate it's offered does not satisfy Fram terms. So that was the defendant's argument. They had expert evidence. There was reference to MPEG LA, etc. The grounds for the judgment start at page 24. I can't take you through it all, but the bit on Frand, let me show you page 52, third paragraph. The actual content of the license offer presented to the defendant by HEVC Advance is also fully compliant with Frand criteria. It is fair and reasonable and non-discriminatory. None of the reasons cited by the defendant against the Framness of the license offer are tenable in the final analysis. There's then a discussion of whether the intrusiveness of the court's scrutiny, but next to the lower hole punch, the court says, in the final analysis, the depth to which the court is required to examine Framness can be left aside because it can be established that a Frand offer, according to all the proposed criteria, was made. From 54 onwards, there is consideration of the royalties. You can see under the heading A, the court is able to establish, first of all, that the royalties charged by HEVC Advance in the licensing agreement are not exploitative, but fair and reasonable. at the top of 55, there's specific reference to the MPEG-LA royalty rates. And there's then discussion of all the reasons why that argument doesn't hold water, which runs all the way through to page 58 over the page. At the bottom of 57, the last paragraph, you can see some more up-to-date numbers about the numbers of patents in the pool, 10,768 patents in the HEVC advanced pool, and how much overlap there is, etc. In relation to non-discrimination.
Sorry, Mr. Seaton, did you say that was at 58? I didn't see it.
57, bottom of the page, last paragraph.
Oh, thank you. Got it.
Those are the more up-to-date figures. And obviously the reason I'm showing this is that the suggestion is made that the reason why these proceedings were commenced is because there was a fear that there was some court somewhere that would consider granting an injunction before considering whether the offer was frank. No such court was ever identified explicitly at first instance, but the concern, insofar as there was one, appeared to be about Germany. And the concern is, on this evidence, thoroughly misplaced, because, as the Supreme Court observed, the German courts do look at frank before deciding whether to grant an injunction. And the discussion of discrimination then goes on at page 63. It goes on for 36 pages through to page 96. And on page 96, the court says, in summary, therefore, the court is convinced that the defendant is not treated unequally for no objective reason in comparison with other licensees. And I think, in essence, the defence failed. I don't need to show you much else. So there is no basis for suggesting that the German court will do anything other than scrutinise carefully in October this year the arguments that are made by Vestel about the PPL. And to make good any case for spin-off value, my learned friend would need to show you by evidence that the German courts, in performing the sort of exercise undertaken in mass Elektronik, would be so assisted by an English decision, which would presumably have to be expedited to an impossible extent to produce any outcome by October. But leave that aside for a moment. Would be so assisted as to warrant bringing a US defendant before the English courts to conduct the exercise at very considerable and entirely duplicative expense. And they have submitted no evidence at all of any such thing. What is more, the second point I make in relation to this, of course, that's summarised in paragraph 46 of the skeleton, is the TQ delta point. Insofar as the Court of Appeal has looked at this issue, they have counselled about that one should be very careful about granting FRAND declarations in the hope of influencing a foreign court. That's Authorities Volume 3, tab 26. These were UK patent infringement proceedings. TQ Delta had succeeded in establishing that Zyxel infringed one of TQ Delta's SEPs, but Zyxel, in view of the imminent expiry of the SEP, said it didn't wish to rely on the FRAND undertaking, and the Court of Appeal found that a FRAND trial in such circumstances was unwarranted. The key relevance for present purposes is that on appeal, TQ Delta said the High Court had been right because the English judgment about whether Zyxel were willing licensees or not would have spin-off value overseas, and the Court of Appeal expressed reservations about that chain of reasoning. And let me just show you the relevant parts. Page 257, paragraph 6, you can see the finding of infringement. Paragraph 7, second line, a substantial further hearing had already been fixed to commence in September 2019 to decide the issues raised on the pleadings concerned with the licence and to settle the terms of a RAND licence. So that's what the RAND trial was going to be. They wanted the court to settle FRAND's terms. And then further down in the same paragraph, on page 257 of the report, fourth line up, in addition, TQD had indicated that it would seek amendments to its statement of case in connection with the declaratory relief sought at the RAND trial. So TQ Delta wanted to amend, and you can see the amendments over the page of 258, paragraph 10. They wanted to seek a declaration that Zyxel are not willing licensees. And then at 11, you can see the declaration is sought on the basis of pleaded allegations that TQ Delta had made offers which were RAND, which had not been accepted, and TQD had not been successful in persuading any company in the Unizyx group to accept a license. So TQ Delta wanted the English court to determine that its offer had been FRAND, and Zyxel had acted unreasonably in refusing to accept it. And the Court of Appeal held that a RAND trial was not necessary in those circumstances. And the passage of reasoning I rely upon is at page 265, paragraph 47 onwards, where Lord Justice Floyd is dealing with the alleged utility of a declaration in foreign proceedings. He says the utility of such a declaration is said to be that it would have effect as res judicata in proceedings in foreign jurisdictions, were TQD to seek to obtain injunctive relief for infringement of patents in those jurisdictions. So it was, can you please determine in advance this issue because I want to use your judgment in a foreign court? And Lord Justice Floyd says at 48 there are a number of quite serious problems with this way of putting the case. He mentions that there are no proceedings in existence. In any event, line 5, the grant of relief in aid of foreign proceedings requires to be particularly closely scrutinised. The second point he makes over the page, second line, is that there is no single Europe-wide, let alone worldwide, approach to the interaction between the RAND undertaking the grant of relief for patent infringement. The third point he makes is that the doctrine of res judicata is a technical one. Mr. Saunders goes no further than saying that a declaration may be res judicata without the benefit of any evidence as to how the finding of this court would be treated in the foreign proceedings. The foreign court may not have a doctrine of res judicata. Fourthly, the concept of willing licensee is not in any sense an internationally recognised term of art, etc. And then one can skip ahead to 52. These considerations force me strongly to the conclusion that the questions on which the court's declaratory judgment is sought are far better decided in the foreign court, where those questions arise, if they ever do. It would be an exercise in jurisdiction imperialism to foist this court's view. So I say that urges a significant measure of caution about entertaining a declaratory action in the hope of producing an outcome in foreign proceedings without any evidence that there will be any spin-off value. And the remaining points I make in that paragraph 46 of my skeleton are that foreign infringement courts are well able to adjudicate on FRAND issues. That's clear from Mass Elektronik. That the German proceedings are already on foot and a hearing is listed for October, and there is a very small percentage of the pool accounted for by UK SEPs. And when you put all that together, there really is no reasonable prospect of the English court finding that it would serve a useful purpose to grant the declaratory relief that my learned friend seeks in the circumstances of this case. That brings me finally to the third stage of the jurisdictional analysis, which is proper forum. The third condition that Vestel was required to satisfy was that England is clearly or distinctly the appropriate forum for the trial of a dispute, and that in all the circumstances the court ought to exercise its discretion to permit service of the proceedings out of the jurisdiction. I've given you the citation for that in VTB, Capital and Nutritech in my skeleton argument. And the overall discretion is an important one, as you will have seen, and the judge cites it. Baroness Hale in Brownlee describes it as an important safety valve. I come then to the question of the time for assessment, which was discussed yesterday. My learned friend took you to Mohammed and the Bank of Kuwait. For my part, I accept that the Mr. Justice Hoffman approach in the quotation from ISC is applicable. So the approach, as per paragraph 7 of my skeleton, and as per Mr. Justice Hoffman's dictum, is that the court is entitled to take into account events post-dating the order granting permission for service outside, if such events throw light upon what should have been relevant considerations at the time. And in that regard, particular reference, of course, was made to the German proceedings. Well, 2 points on that. First of all, the fact that German proceedings have been issued sheds light on what should have been a consideration at the time, i.e. that if Vestel was to be compelled to take a license, that would have to come from infringement proceedings. And whichever court was seized with those proceedings would be well able to determine FRAND for itself. Indeed, as I've shown you, the only threat, if it can accurately be characterised as that, and I appreciate a great deal of jurisprudence on that, I use that in the non-technical sense, came in a letter from German lawyers. And there was reference to an apprehension of proceedings in Germany. So the fact that proceedings have actually been issued simply sheds light on what should have been a consideration at the time. The second point is this. I don't accept that my learned friend is entitled to ask the court to take a strict approach to the timing issue when he is running a case that his client did not have before Deputy Master Linwood and did not have before His Honour Judge Hacon. If we assess jurisdiction on the basis of the materials and the arguments at both instances in the High Court, the answer is clear and has already been given by His Honour Judge Hacon. And my learned friend, as Mr. Pickford has pointed out, is not really appealing those answers, but is running a different case in this court. So one has to have a measure of common sense in the application of the timing principle and Mr. Justice Hoffman's dictum. And one cannot be too strict about these things. But in any event, I do say I'm within Mr. Justice Hoffman's dictum. And essentially, for all the reasons I've already outlined, Vestel hasn't come close to showing, as it has to, that England is clearly or distinctly the appropriate forum. My client is a US company. Vestel is a Turkish multinational. No SEP owner in the pool has brought any action for it, or even threatened infringement, proceedings for infringement of UK rights. No one has brought an action for a declaration of non-infringement of UK rights. A very small percentage of the patents in the pool are UK patents. There is no reason to think that an infringement court elsewhere would be incapable of dealing with FRAND issues if and when they arise. There is no evidence of any spin-off value at all. Indeed, it's hard to see how there could be when it's not even clear what legal standard the English courts are being asked to apply. The exercise of assessing FRAND is already scheduled to take place in October this year in Germany, and Vestel will be able to ask the German court to consider all the points it wishes to make about FRAND. As we've seen from Mass Elektronik, those points will be carefully considered. What one is driven to in the end is the conclusion that the real reason Vestel wants to try to get the courts involved in England is because it fears that the German courts will decide that the PPL is FRAND, as they did in the Mass Elektronik case, and Vestel therefore wants to chance its arm to see if the English court decides differently, in which case it will try to use a judgment to that effect at some stage in Germany. And that is simply not a proper basis, in my submission, for bringing a US defendant before the English court to face a declaratory action, still less where there's no articulated legal basis for the exercise that is proposed. So for all of those reasons, we say that the High Court was absolutely right that there should not be permission for service outside the jurisdiction and that the appeal should be dismissed. Unless I can assist further, those are my submissions.
Thank you very much. I have no further questions. Justice Laing or Justice Birss? No. Thank you very much. And that's a convenient moment to take a break. It's 3 minutes past 3. We'll resume at 13 minutes past.
James, just so you know, you're not on mute.
That's probably quite helpful, and thank you. Is there an answer to the query yet? Or am I going to have to ask the court to sit in private?
I'll answer I'll try and answer the query.
Okay.
So I'll do that at the beginning. If you want to raise it at the very end, just shout.
Right, okay.
It'll be a surprise.
Yes. So, Mark, you say you're going to say something about this. What are you going to answer the question?
We haven't been able to get instructions on that. I am going to confirm to the court that it is our position that the appropriate FRAND license to grant in respect of the UK SCPs is a global FRAND license, and that's the position you see in our pleadings, but I haven't been able to get instructions to refer to the terms of the detailed offer.
Mark, it's been drawn to my attention. The answer's actually already in the bundle, in the confidential annex, the particulars of claim, which is in the confidential bundle. So since I can answer the question that he asked me, I'll show them that when we go back.
Okay, fine.
Yes, I think we're all reconvened.
My Lord, before Mr. Chatsfield replies, I should address your Lordship's question about whether there was ever an offer for the UK loan. And it has been drawn to my attention that, in fact, the terms as regards royalty that were counter-offered are actually in the confidential bundle, in the confidential annex to the particulars of claim. And it is going to be either in tab 1 or tab 2. I think there's a slight bundling issue. It's in tab 2 of my bundle, but
Annex to the particulars of claim.
yes, exactly, yes. And you could,
Seems to be in tab 1 of mine. Dated
okay.
18th of January.
Yes, exactly. And you'll see from the entries that the offer was simply a markup of the global PPL. I can't read out the terms that are there, but that is the answer.
Yes, I see. Thank you very much. Mr. Chatsfield, ready?
My Lord, I'm very grateful. I'm very grateful for the 10 minutes as well, because the television in my solicitor's office went on the blink, so we've done a hasty room move in that in the last few moments. My Lord and my Lady, Vestel comes to this jurisdiction, that is its largest jurisdiction worldwide for the Vestel Group, for televisions and for the HEVC televisions in particular. I was asked a question yesterday by my Lord Justice Nugee about the market, and I may not have been quite clear enough when I responded. The evidence is, and I can take it if it helps, but the evidence is that the UK is not only 90% of the second claimants market, but it is the largest market for the Vestel Group worldwide for televisions generally and the HEVC televisions specifically. This action is brought to try and achieve some clarity as to my client's exposure here, and it is brought to try to limit the remedies potentially assertable against it here in its largest market. Now, it is also the case that if on the facts a FRAND licence to the UK SEPs is a worldwide licence, then we will seek that, and that will have advantages in other jurisdictions. It is our case that a FRAND licence is global, and I don't shy away from that. The position was exactly the same in Unwired Planet and exactly the same in Conversant. But if we're wrong on the facts, then the court in this case, if it's allowed to proceed, will declare the terms of a UK FRAND licence. So it's said that this jurisdiction is the wrong one, despite being our worldwide largest market. And it's said that this is the wrong one because the patentees have later decided to launch proceedings in Germany. Now, we submit it's entirely proper and appropriate for this action to be resolved here, and we submit that we satisfy the test required to do so. I'm going to start, if I may, with Gateway 11, because that is no doubt my simplest case. It was advanced in the original pleadings and in the evidence to serve out. It was addressed before His Honour Judge Hacon. And whilst I do need permission to amend, the scope and effect of the amendment is clear. And it's striking how little of the submissions have been directed to this head. I'm then going to consider Gateway 9 and Article 7.2. So, Gateway 11, what's become a major issue for my learned friends is this Huawei and ZTE point and the structure of the case that is brought. And it's important to put this in its correct procedural and legal context. I took my lords and my lady through the pleading yesterday, and the claim is to declaratory relief is pleaded. I've shown you that the pleading sets out the parties, the patent pool, including the UK SEPs within it, the ITU FRAND obligation, the dispute between the parties and the injunction threat, Advance's threat of hold-up, the pleading of the problems with Advance and Philips's licence, why we say our licence is FRAND, or in the alternative that we would be willing to take a court-declared FRAND licence, and a claim for relief. But note, this is not a pleading which seeks to force the respondents to give us a FRAND licence in this action. It is a plea for declaratory relief which would provide us with several significant benefits, which I've outlined to you before, but including circumscribing any available relief, as previously discussed, as well as removing the uncertainty as to our financial liability, at least here and potentially more broadly, as well as things like spin-off value and also clause 4.1 of the pool contract, which I've addressed you on yesterday. What is said against me is that we've not pleaded the further details of why the declarations would operate as a complete or alternatively partial shield to a future action for infringement of UK patent rights. Now, we do plead the threats and the whole, but just not the future consequences of the declaratory relief in a separate future action. Now, this is not, in my respectful submission, a point the absence of which goes to any question to do with jurisdiction, and particularly so under the property head. It is a legal argument in support of part of the case as to useful purpose. Now, you will have just said that Gateway 11 has been in the case since the outset. And can I remind you of what was said by Mr. Moss in his first report at 24B, so that's supplemental tab 5, page 23. and also paragraph, and then in page 26, you've got paragraphs 30, D and E. So this is a case that's been advanced since the evidence on service out. It was advanced before His Honour Judge Hacon, and my learned friend, Mr. Segan, took you to my client's skeleton argument in front of His Honour Judge Hacon. And if I could pick up on that, it's in tab 23 of the bundle. And if I could invite my lords and my lady to look at paragraph 45 on page 190. And then also paragraph 52 on page 192. In particular, the second half of that paragraph. So the first half deals with a declaration across patents generally, but the second half deals with the more limited declaration, which is found in the amendment, which we've seen in paragraph 93, specifically limiting the determination of the terms of the license for the EPUK patents only. And that is the case advanced in the alternative then, but that is the case that's advanced before my lord and my lady now, in respect of Gateway 11. Now one has to consider the nature of the property gateway. The declaration must relate to property within the jurisdiction. To fall within this gateway, it does not need to operate as some kind of shield to an apprehended action in tort. It requires only that the claim relates to property in the jurisdiction. And that the pleaded claim does, since it is a declaration that relates to UK SEPs. And the fact that the relief may or may not ultimately turn out to be a global license or a national license does not affect that. And I'll come on to that. But when considering the Huawei ZTE point, it doesn't arise in respect of the gateway, because it's no part of the gateway that the declaration has to act as some kind of shield to an apprehended action under this head, by Gateway 11. If the argument has any role in this case, it is in respect to the question of useful purpose and real prospect of success in the second Brownlee question. What my learned friend's case really is, or at least ought to be, is that because they say Huawei and ZTE is not pleaded, then I am disentitled from relying on the question of useful purpose on any argument which takes as a step in that argument the Huawei and ZTE obligation on the patentee to make a FRAND offer before initiating proceedings. But note 3 points here. Firstly, this highlights that the argument is not a point about, this highlights that this is the point about not pleading legal arguments in support of the useful purpose case. It's about legal arguments, and secondly, therefore, correspondingly in my submission, being as a matter of legal argument, it is appropriate and allowable for me to take the point, even though it's not pleaded. It is basic that one does not plead legal arguments, one pleads facts in the normal way. And what's more, as I've said, this is about the consequences of the declaratory relief and the later action. And thirdly, this does not go, in any event, go to all of the points on useful purpose. For example, the declarations at a very minimum would dispel the commercial uncertainty in the UK as to our exposure here under the UK SEPs. Potentially, there's obviously arguments about this that would need to be resolved at trial, but potentially also spin-off. And the point I've made in respect to clause 4.1 of the pool contract. I'm going to come on to the tort heads later on, where the analysis is potentially a little more complicated. But as regards the property head, in my submission, this pleading point has actually a very modest role to play. So, picking up from just some other points you made, my learned friend Mr. Segan says in respect of the Huawei ZTE point that this is an attempt to revive the abandoned case that is no longer pursued. Now that is wrong. The case that was no longer pursued, as I made very clear in my supplemental note, was the case that by charging excessive rates, we were being caused by the mere fact of the excessive nature that was asked of us, and that did not succeed on the evidence. And I accepted in my note that we were not able on this appeal to challenge the judge's findings on the evidence that was then before him. That's an entirely different case to saying we want declaratory relief in the nature that one has seen, which will provide us to a shield to a future patent action in the UK. Now, that takes me on to the question of amendments. At a broad level, Mr. Segan referred to Alliance Bank for the proposition that the applicant needs permission to rely on further causes of action. And I accept this. The question is whether I need to make any amendments, and insofar as I do, whether I have been or should be granted permission. Now, when it came to amendment, my learned friend Mr. Segan in his submissions largely adopted the submissions of my learned friend Mr. Pickford. But Mr. Pickford's submissions were all about the new tort case. And I do, as I've said before, I accept that that is a new case, albeit it is my position. It's one that Lord Justice Floyd gave us permission to run a year ago. And so my learned friend Mr. Pickford took you to his interaction with Mr. West in front of the judge. And I accept that Mr. West said what he said at that hearing, and I accept that this is a new case. But none of those submissions is addressed to Gateway 11, which is what I'm currently talking to my lords about and my lady. The procedural context here is very different. This is a case that's before His Honour Judge Hacon, and it was addressed in the service out evidence. And the arguments here about patents within and without the jurisdiction and the role of Unwired Planet and Conversant are the same as were before His Honour Judge Hacon. Now, Mr. Segan said just before lunch that the abandonment of the tort claim for abuse of the dominant position by excessive pricing had a dramatic effect on the property claim. He asserts that, but he's never actually said why. He's given no examples of this or any detailed explanation. And as I've just said, my submissions before my lords and my lady are essentially the same as those that were advanced before His Honour Judge Hacon. And I've shown you that those little parts in the opening skeleton argument. Now, I do accept I do need permission from my lords and my lady to amend to introduce the 93A declarations and to conform the claim form. But in my respectful submission, that amendment should be allowed if the claims are otherwise within the jurisdiction of this court. And my learned friend, Mr. Segan, has identified no reason why allowing that amendment would be prejudicial or unfair. And it was one that was considered by the first instance judge. Moving then to the questions of property within the jurisdiction. One has to look, in any case, as was done in Unwired Planet and Conversant, and we submit here, at the property to which the declaration relates. My learned friend seeks to elide, in the same way as was rejected by Conversant Unwired Planet, the question of the property the property which is the subject matter of the action, and the scope of the declaration which the court may give. Namely, the court may give a global friend declaration. Now, he seeks to distinguish Unwired Planet and Conversant on the basis that those were claims where an action for infringement was brought, in respect of which the Fran defence was raised. Now, that is a correct characterisation of those cases. But we say that this case is just the reverse of that. We are seeking a declaration, proactively a defence, to the EPUKs in the portfolio. It is just like, as was addressed by Carr in Conversant at first instance, which is in tab 21. And my learned friend took you to paragraph 69, but if I could do so as well, please. It says, in Unwired Planet, Birss J, sorry, this is 646 of the judgment. In Unwired Planet, Birss J held that global licence was frowned on the basis of evidence as to industry practice, and comparables agreed between willing licensors and willing licensees of set portfolios. Whether such relief should be granted in the present case will be a matter for the Fran's trial if liability is established. If these claims were stayed on the basis of form non-convenience, then the consequence would be that the English court could not decide upon the infringement of UK patents and could not decide what relief it would be appropriate to grant when such patents are infringed. That, in my judgment, would not be in the interest of all the parties and end of justice. Well, if these claims are stayed, my clients will never be able to resolve the question of their liability under the UK SEPs and what relief it would be appropriate to grant in respect of them, even though this is our largest market worldwide. In Conversant, in paragraph 10 of Conversant, the judge records that only 1% of, I think it's the Huawei defendants' business was located in the UK, and 0.07% of the ZTE defendants' business was located in the UK. The action nonetheless proceeded there, yet it is said against my client that it cannot do so despite this being its largest market. Now, we say, as I said, our case is, of course, the reverse of Conversant and Unwired Planet. But in my submission, the reversing of the claim does not affect the subject matter of the property, which is the subject matter of the claim. The gateway asked where property is situated, and it doesn't matter for that purpose who is the claimant and who is the defendant. And frankly, my lords and my lady, that's really it for Gateway 11. The question of really, in my submission, the question before my lords and my lady on Gateway 11 is whether it is right to say that the analysis in Unwired Planet and Conversant does apply to a negative declaration sought in respect of UK SEPs, or that it does not apply. And my learned friend has advanced no logical or legal reason why, by the reversing of the roles of the parties, it makes any difference to what falls within the gateway. Now, my lords, I was going to move on to the tort head. I wasn't sure, my lord or Justice Birss, I don't know if you're speaking or mute or not, sorry. No, okay.
Well, can I ask you a question, Mr. Jackson, before you leave Gateway 11? Let's assume for the moment that you fail against Mr. Pickford. So Phillips are not in the action. So you don't have a tort claim against Mr. Pickford. And you fail on the tort against Mr. Sagan. So all you've got left is your Gateway 11 property you rely on are Phillips's UK patents. UK designations of EU patents. That's the property.
The property is all EP UK's, so UK designations of patents within the advanced portfolio. So it's all.
Sorry, it's yes. Philips plus, because Philips is a representative. So it's all the UK patents.
Sorry. So if I succeed, so Mr. Sagan is for advance, and Gateway 11 is against advance.
Yeah.
So if I succeed against him, it's all patents.
All UK patents in the portfolio.
Which designate the UK, yes, that's correct. And as regards Mr. Pickford, it is also correct, as my lord just pointed out, that he is sued in a representative capacity as well as.
But you don't have Gateway 11 against him because it's a Brussels thing. So if one just looks at the claim proceeding against Advance alone, Advance doesn't own any property at all, as I understand it.
It doesn't own property, that is correct. As I understand it, it is a licensee of the property, though.
Is it a license? Anyway, I'm not sure we know that. What we know is that it has authority to enter into the PPL on behalf of the patentee. I don't know that we know that it has any license.
Well, I've just asked, sorry, I'm sure some of this room can have a look and just see if there is an actual pleading as to that. So I'm just having a look at the pleading on that particular point. But certainly Advance has the authority to negotiate licenses on behalf of all the patentees, and there is a pleading that it acts as agent for those parties. And I have explained to my lord in opening and my lady in opening the useful purpose of achieving a declaration as against Advance itself. And you may recall its issues, the reality is we will be offered that license because otherwise the Article 101 and 102 points would be horrific. And in any event, in terms of my, as it were, I can call them my shield arguments, they would apply in my submission just as much to a declaration against, sorry, let me rephrase that. As Advance, as regards to shield type arguments, they would apply just as much if the declaration is against the Advance itself as the pool administrator, as if it was against the individual patentees, and for all the same reasons.
That's what I was struggling towards. If you've only got a cause of action against Advance, and Advance doesn't own any of the patents, Advance doesn't have any property, in what sense does your proposed declaration concern property when the only property you've put forward are patents belonging to someone else? And it's not obvious to me that a declaration against Advance would be of any use against the patentees, who are the property owners, who wouldn't be bound by the result of the action.
Well, they wouldn't be, well, in a sense that they would be bound as privy to that action.
Why would they be privy to the action? They're not parties to it. You haven't sued them.
That's true, we haven't sued them. So I'm just having a look for it. So it is pleaded in paragraph 85 that Advance acts as an agent for the pool members in this regard. And the fact that I haven't sued a patentee doesn't mean that they're not privies with a party that I have sued. It depends on the scope. That goes back to the law of privity, which doesn't require for, even for res judicata in the strict sense, let alone a Henderson type scenario in the looser sense, it doesn't require you to be a party to the earlier action. It does require, of course, an appropriate link to the earlier action, or to the between the parties.
So, can I be sure I've understood this correctly? Your submission, you come in that the claim against Advance falls within Gateway 11, is that it would be useful to you to have a declaration as to what a FRAND license consists of. And the reason it would be useful to you is, even though Advance itself owns no property, you would in practice be able to rely on it as a shield against the claims of people who do own property.
Yes, indeed. It's slightly different, I accept, than seeking a declaration against the tenant of property, because obviously the interest is slightly closer. But nonetheless, this is a company which is administering a pool of intellectual property rights on behalf of intellectual property, on behalf of the owners. It is involved, as you will have seen from the paragraph 4.1, in decisions to litigate those intellectual property rights. Decisions to, well, I've got to be a little bit careful as to what I say publicly, but decisions as to against whom litigation should be brought are made involving Advance, and I can show you the more detailed terms of that if that would assist. That's in clause 4.1 we looked at.
Yes, we looked at that. Yes,
indeed. So it's not just the case. You know, Advance is intimately involved in this whole licensing and litigation process. I accept, my lord, that in a subsequent action, it may be possible for a patentee to raise this point, and that would have to be resolved. I don't accept they would succeed. In fact, in my submission, they would likely fail in circumstances where Advance is their agent for the purpose of negotiating licenses, enforcing the rights, and is involved in decisions to litigate. So I think Mr. Pickford has, in a primary school sense, got his hand up.
Yes. Mr. Pickford.
Thank you very much. I hesitate to interrupt, but I'm a bit concerned here that we seem to have had the latest radical development of a case, which seems to be changing every time Mr. Chaxfield speaks, which is now it's said that the useful purpose here somehow, one of the reasons for the useful purpose is because my clients are going to be bound, some have somewhat matter of privity by the actionist Advance. That has never been suggested at any time hitherto. If it had been pleaded, if it had been set out in evidence, I would have come here to meet it. But this is an absolutely brand new case, yet again. And
because he's being asked a new question.
My lord, indeed. And also, I'm not relying upon, I was asked a question which I'm responding to. I'm not relying upon this as a ground in which to drag Mr. Pickford's client before this court. If even at a later date I obtain a declaration as Mr. Segan's client, and then Mr. Pickford's client decides to sue me in the UK, despite the terms of a declaration granted by the High Court, then obviously this is the conversation we can have at that stage. I'm not relying upon it against him today. It's just a question my lord answered, and I was answering my lord's question.
Well, I think I made my concern clear, my lord. There is a problem here.
Thank you. Yes, do please continue.
So my lord,
sorry, Mr. Jackson, I've got a different question for you. Can I make sure? I think I've understood the point you're making on the gateway, gateway 11, the property gateway, but I just want to make sure that I have and reflect it back to you. I think the submission that you're making is, you say that in order to decide whether to be in gateway 11 or not, the question isn't whether your underlying claim, whatever it may be properly arguable or have a good arguable case. You say that's a different question. Your case is that to decide whether you fall within gateway 11, you take whatever the claim is you're making for good or ill and ask whether it falls within gateway 11. If it falls within gateway 11, then you pass gateway 11. The remedy, if that's the right expression, for whether your claim is arguable or not is the next question, because you then have to satisfy a different test under Brown, which is whether your cause of action or your basis for bringing a claim or whatever you want to call it is properly arguable or not. Now, you know you have to satisfy both tests, but your point is that what your opponents are doing is mixing together the arguability of your claim with whether it satisfies gateway 11. So I'm going to put it in an unfair way. Your claim may be completely hopeless, but it still falls within gateway 11. Now, I know you don't say it is, I understand. But that's part of the point you're making in your submissions.
That is exactly right. That is exactly right, my lord. And throughout the submissions that have been made in this case, there has been a real mixing and matching of gateways and tests and amendments and permissions to rely upon points by my learned friend. And it is really important to be precise. And my lord has entirely correctly understood what my submission is.
It might be said against you that the real problem is because your claim is untethered by any proper claim. That's why you're having such difficulty with Gateway 11, because you haven't really got a claim at all.
Well, I'm sure my learned friend does say that. Obviously, I disagree. Well, and I do have a claim. I do have a claim for declaratory relief. In terms, I think by the tethering point, my lord is referring to what the ITU friend obligation issue, which I will come on to. And I don't accept it's untethered in any sense. But certainly in terms of how I structure the analysis of the Gateway 11 and then the second Brownlee test, my lord entirely has my point.
Thank you.
I was then going to turn to Article 7.2 and Gateway 9, tort heads. Having heard my learned friend Mr. Pickford's submissions, they really collapse down in my submission to two basic points. First is the question of whether a declaration which seeks to limit or establish the extent of the remedies available in respect to the tort within Article 7.2 or for Mr. C in Gateway 9. They say that, and they have to say in the light of Foley and Fisher, a putative or what they call normal defendant can bring a claim if that it serves to establish that they have no liability, but that you cannot bring a claim if you're just trying to establish you have a lesser degree of liability or to establish the scope of your liability. We say that's wrong, and I'll address you on that in a moment. And secondly, the second issue is as to the proper characterization of my client's case. So, starting again with Huawei ZTE point, I accept that the analysis here is a little different from the property gateway. And the difference here arises from the fact that to fall within these heads, that's 7.2 and 9, the declaratory relief has to relate to tort. And therefore, the question of the role of the declaration as providing some kind of shielding or clarificatory or similar effect is relevant to the gateway question, not just the useful purpose question. So I accept that. Nonetheless, I maintain my submissions as to why the declarations satisfy these heads too. Now, it remains the case, for the reasons I've explained earlier, that this criticism is at its core a criticism for not pleading a legal argument relied upon, as opposed to not pleading the cause of action at all. And second, it's also the case that whilst I do maintain my full arguments, some of the points relied upon, such as the delimitation of the scope of our liability under the UK SEPs, spin-off, article, the paragraph 4.1 point, remain relevant in any event to the question of the tort, because those are not directed at establishing a shield in the Huawei ZTE sense, but they are declarations which serve to delimit and define our liability. Now, one of the points which has been debated is whether a negative declaration has to be such as to completely abrogate liability, or whether a partial delimitation or restriction on the ability to obtain remedies is also within these heads. Now, in my submission, the suggestion that the Article 7.2 and Gateway 9 exclude a declaration which only partially serves to delimit the extent of liability, as opposed to it's completely extinguishing it, cannot be the law. I'm going to take an example. So a French delivery firm is sued by its Italian clients for the negligent delivery in the UK of goods, which results in damage to the goods. So, for example, a valuable painting is damaged as it's taken out of a van. The negligence and damage both occur in the UK. Now, the delivery firm alleges that the Italian firm was contributory negligent to the tune of, say, 50% because it failed properly to package and protect the painting. And it seeks a declaration from the UK courts to that effect. Now, my submission that would plainly fall within Article 7.2 or Gateway 9, it relates to negligence. And yet it's not seeking a complete abrogation of liability, merely to establish that the exposure is limited to 50% of the loss. And that would also be so, the declaration served not only to declare the 50% contributing negligence, but also to determine the actual amount of the van owner's liability. Now, in my submissions, those would clearly fall within Gateway 9 and Article 7.2. And can I show you, and we say just as true, let me start again. We say that that is just as true for our case as it is for those slightly conceptually simpler scenarios, even on our minimum case of just resolving the extent of the UK liability for the infringement of the UK SEPs. And obviously it's a fortiori in the other heads we advance as to why the declarations relate to tort. Now I'd like to show my lords, if I can, the Folian-Fisher case, which is in JA3, at tab 30. And if I can start at 36. And ask my lords to read 36 and, my lords and my ladies to read 36 and 37.
You say that you mean paragraph 36?
Sorry, paragraphs 36 and 37 on page 545 of the document. I'm afraid I don't have the pages to assist my Lord Justice Birss in the electronic bundle. Paragraph 30, so 545 of the internal numbering of that decision, paragraph 36, under the title Scope of Article 5.3 of the regulation.
Thank you.
So 36 and 37 address the common factors of proximity and predictability, and in particular talk about proximity here. And 38 says, in matters of tort or delict, the cause of the place where the harmful event occurred or may occur are usually the most appropriate deciding the case, in particular on grounds of proximity needs of taking evidence. So that is the policy consideration which underlies this. It's the question of proximity. And then down at 41, the court goes on to consider negative declaratory relief and says, it's therefore a question deciding whether, notwithstanding the special nature of an action for negative declaration, jurisdiction to hear such an application contributes on the basic criteria laid down in Article 5.3. And by special nature, you'll see they're talking about the reversal of the roles of the normal claimant defendant. It says in 42, in that regard, it should be noted that the special nature of an action for negative declaration arises from the contractor claim seeking to establish the preconditions for liability, as a result of which the defendant would have a right of redress, are not satisfied. In that context, the Advocate General observed in 46 of his opinion, an action for negative declaration entails a reversal of the normal roles in matters relating to tort and delict, since in such an action, the claimant is a party against whom a claim based on tort or delict might be made, whilst the defendant's party of tort or delict who may have been adversely affected. And 44 says, however, that reversal of roles is not such as to exclude an action for a negative declaration in the scope of Article 5.3. And then paragraph 45 again talks about the foreseeability and predictability and proximity. Now, down at 51, the court concludes, in those circumstances, the special nature of the action for a negative declaration, referred to in paragraph 42 above, has no bearing on the examination that the National Court must carry out in order to determine whether it has jurisdiction matters relating to tort delict or quasi-delict, since the only matter to be established is whether there is a point of connection with the member state in which the court is sitting. If, therefore, the relevant elements of the action for a negative declaration can either show a connection with the state in which the damage occurred, or may show a connection with the state in which the causal event giving rise to the damage took place, in accordance with the case of paragraph 39, then the court in one of those two places, as the case may be, can claim jurisdiction to hear such an action pursuant to Article 5 of the regulation, irrespective of whether the action in question has been brought by a party whom a tort or delict may have adversely affected, or by the party against whom a claim based on tort or delict might be made. And then it goes on to the conclusions that we've seen. But what's important here is the court says this applies absolutely irrespective of who the claimant and the defendant are. The only question is whether you have the suitable proximity in the sense of the causal event arising in the jurisdiction or the damage arising in the jurisdiction. Now, my learned friend, Mr. Pigford, accepted earlier today that a claimant bringing a claim to determine, say, loss where liability is not disputed would fall within Article 7.2. But in my submission, and frankly that must be right, but in my submission, the consequence of that, given the analysis is Foley and Fisher, is it's absolutely clear that the reverse is also true. Now, for those reasons, I submit that the submission of my learned friend Mr. Pigford, which is also supported by Mr. Segan, that the Article 7.2 and Gateway 9 allow a negative declaration insofar as it seeks to establish non-liability, but not insofar as it seeks to establish the extent of liability or the extent of relief available. It is untenable. My lord, that's what I was going to say on that, my lady. Permission to amend. My note from Mr. Pickford has again sought to run together the points of permission to amend and the question of what arguments I have permission to run. He did not, in his submissions, at least as far as I could tell, contradict my submission that I have permission from Lord Justice Floyd to take the point on the tort of patent infringement. And that must be so because I have an order that says I can. In terms of the pleading amendment, my learned friend Mr. Pickford ran a point, and this for your note was at T1 214. He said that when Ground 2 was introduced, he said, and this is to quote him, we do not really understand that. It is a claim for patent infringement or is it a claim for abuse of dominance? We are confused. And then he said that the amendments in February of this year clarified this and made it clear the claim was brought only in respect to the tort of patent infringement. Now, with respect, this mixes up two separate issues. One is the issue of permission to run Ground 2, and the second is the permission to delete matter relating to, sorry, I've got those the wrong way around, the permission to run Ground 3, and then permission to delete the matter relating to Ground 2. Now, his first point that he didn't understand Ground 3 is really, in my respectful submission, untenable. If my lords look, and my lady look at the grounds of appeal, which are in the core bundle, I presume, Ground 2, tab 2. Yeah, tab 2. Ground 3 is set out on pages 12 to 13 of the bundle, paragraphs 8, 9, and 10. And paragraph 9 says it's the defendant's case that the acts undertaken by Vestel UK in the UK necessarily infringe the UK SEPs in the pool, including those owned by Philips, and as such, the acts are said to constitute a tort. Such acts are said to lead to damage and may lead to damage in the UK, in respect of which acts a licence is required. Further, said acts lead or may lead to corresponding damage to Vestel UK in terms of liability for UK patent infringement and commercial uncertainty in the UK. Now, the commercial uncertainty is not ahead of damage, it's a statement of fact that it leads to commercial uncertainty. The damage is the liability and the accruing exposure to a claim for UK patent infringement. And in paragraph 10, according to the judge, ought to have held that this action related to tort in which harm or potential harm in the UK has occurred or may occur, and a claim is made in tort where the damage was sustained or will be sustained in jurisdiction resulting in that committed or likely commission in jurisdiction. Paragraph 3 above is repeated. Further, declarations sought fall in the scope of Article 7.2 since they seek to establish the absence of liability in tort. It's absolutely clear this is the negative declaration case because we're seeking to establish the absence of liability in tort. And if my lords and my lady can look at paragraph 3 on the preceding page, to which you've just seen the cross-reference, this says, further, the judge overlooked commercial uncertainty of Vestel UK arising from the demands made by HEVCA. This justifies the exercise of declaratory jurisdiction of the court in respect to the proper friend terms applicable to UK patents. So there we plead the exercise of the declaratory jurisdiction of the court. Now, second one turns to the amendment. In my submissions, my learned friend simply has not attempted to actually show that the amendments, the deletions, have changed the case in any way. He has asserted that, and he asserted that repeatedly. But I have shown my lords and my lady the way I base my case on the remaining material, the undeleted material. And Mr. Pickford has not said, well, paragraph X that Mr. Chaxton relies upon had one meaning before the deletions, and that's changed by reason of the deletions for the following reasons, blah, blah, blah. And that's what he has to do if he wishes to maintain his submission.
And that is my case.
Fine. My Lord, and of course, my Lord Justice Nugee pointed out in argument yesterday, the tort of patent infringement is a new legal argument on old facts point. It's not an amendment case. And the test for that is, my Lord was right about the test. It's actually set out for your note, if I may, in the white, this section of the white book, which is exhibited in JA1 tab 5, page 3. And again, for your note, in particular, there's three propositions made by Lord Justice Haddon Cave in a case called Singh. So I'll give you a moment to turn that up. It's page 4 in tab 5. So he says, first, an appellate court will be cautious about allowing new points to be raised in appeal that was not raised before. Second, the appellate court will not generally permit a new point to be raised if that point is such as either would necessitate new evidence or would have resulted in the trial being conducted in a different manner. And thirdly, even where the point might be considered a pure point of law, the appellate court will only allow it to be raised if three criteria are satisfied. The other parties have adequate time to deal with it, they've not acted to their detriment, and the other party cannot be adequately protected in costs. Now, first, my primary submission is that I've got permission to run this from Lord Justice Floyd's order. But in any event, they've had notice of this for a year. They addressed it in their first skeleton argument. They addressed it in their recent supplemental replacement skeleton argument. It doesn't suggest any additional evidence would be needed, and the facts are clear here. The arguments are as to the application of the law, and then there just remains the potential an argument about costs. So although my primary case is I have permission to run the tort heads, insofar as necessary, then I do seek permission from this court. Turning to the legal test under Gateway 9 and Article 7.2. Actually, I think, my lord, I think I was working up to Foley and Fisher. I think I can just skip this, actually, given the time. I'll actually just make one point on this, which is my learned friend and I had a bit of a proxy war going between us as to whether you call the head of the scope of the 7.2 and 9.1 broad or narrow. but in a sense it's an arid debate. In a sense we're both right. The test which you've already been shown in Cal Fetis is whether there is a wrong-based liability other than falls within the contract head. So accordingly, it's common ground that this excludes contractual claims or things falling within Article 7.1. It's also common ground that this does not include non-wrong-based liabilities of the type discussed by my learned friend Mr. Pickford in his 3 cases, the Reichardt case, the Climate Benson case, and Exo Insurance. Now, I categorise that as a broad test in that Cal Fetis includes any wrong-based liabilities which is not within contract. But it is narrow in the sense of it does not go beyond that. And as set out in AMS, if you're not within the tort head, you can't bring other things with it. And it's also narrow in the damages sense, which is that you can, if you're relying on the damages head under Article 7.2, then you can only rely upon what in European law is the direct damage and not the indirect damage. But what matters for this case is not whether you call it broad or narrow, it's what the test under Cal Fetis is. And I've addressed that in opening, and I've talked to you about Cal Fetis and Foley and Fisher, and then Abvi. Now, the next point, I think, relates to the patents. My learned friend, Mr. Pickford, said no patents are pleaded or identified. That's actually incorrect. Annex B to the particular claim, which is not in the bundles, is a list of the advanced sports, the patents number, the proprietor, the country where it's registered. It's referred to in paragraph 9 and footnote 3. Now, it runs to 280 odd pages, and we didn't think it was something that necessarily satisfied the 52C practice direction of matters that my lord and my lady might need to pre-read for the purpose of this hearing. But it is not correct to say that the patents were not pleaded. He also says that there's, sorry. He also says that there's no identified tort in the no tortious act in the jurisdiction, and there's no identified damage. He said the tortious act and the damage relate to the liability my client accrues under those patents identified in Annex B insofar as they relate to the UK. My learned friend Mr. Segan addressed Fujifilm, and the thrust of his decision was that it was an obiter decision. Now, he also sought to build, it was an obiter decision. He also accepted implicitly that the test, however, is one which must look at the substance of the declaration claim, not the form of the declaration claim, because he relies upon 107 where that proposition is made by Mr. Justice Arnold, as he was then, and he does not demur from it. But again, they take the hardline approach that Fujifilm only allows a negative declaration where that declaration is to the effect that no tort has been or will be committed in the jurisdiction. Now, I say that's wrong by parity of reason with Foley and Fisher. The other point I would make is I don't want to have to go to Brownlee given the time, but in Brownlee, the argument, albeit it was an obiter argument, was whether the head of Gateway 9 was broader than Article 7.2 in terms of the test of direct versus indirect damage than the case law of the Court of Justice on Article 7.2. Lord Sumption, to whom my learned friend took you, was on the minority with Lord Hughes. The majority, albeit obiter view, was the leading judgment there is that for Baroness Hale, and she concludes that the test for the test on Gateway 9 is broader, if anything, than the test under Article 7.2. And I can give you that, and that's paragraphs 50 and 51 of the judgment. And that also apes the analysis of Lord Justice Arnold at first instance in paragraph 106 of Fujifilm, where he makes the same point. And sorry, the point she makes is that the broader scope of the gateway is in part controlled by the addition of forum, which doesn't exist under the as a concept under the European case law. My learned friend pointed to the part of the decision of Lord Sumption where he's addressing the exorbitant jurisdiction statement. In fact, Lord Sumption there, if one reads it, it is addressing a different point, which is whether the role of the gateway should be downgraded or abandoned completely. Now, turning then to the question of whether this is a non-justiciable claim, the approach to Frand was addressed by the Court of Appeal in Unwired Planet. If I can show you this, it's paragraph 28 and in JA2, tab 23. And if I can ask my lords and my ladies just to look at that, it's page 777 of that decision. It says, there was no real dispute at trial as to how Frand terms should be assessed, at least in general terms. The task of the tribunal is to identify terms which would be fair, reasonable, non-discriminatory. The judge directs himself correctly, in our view, that relevant matters will include what a willing licensor or a willing licensee in the relevant circumstances actually that hold up or held out would agree, etc. Now, it is correct that I do not have a pleading of the type that Mr. Pickford identifies in respect to the ITU term, saying what term, when, in what form, who agreed it, when. Now, that's an objection of a lack of particularisation. And the standard approach in this kind of case is that the court will order at the CMC the parties to produce statements of case on Frand. And these typically run to 40 or 50 or 60 or more pages. Now, the lack of a Frand statement of case at this stage in proceedings is, in my submission, entirely usual. Now, I accept that that is a matter for directions at the CMC, and no doubt Frand statements of case would need to be produced in this case. But that's not a question of justiciability, that's a question of the appropriate directions to make on a CMC. My learned friend also refers to the office depot case. Now, that's a very odd case. I haven't got time to go through it, I'm afraid, unless my lords and my lady would particularly want me to. But what happened there is the claimant sought to put before the court a number of different approaches that could be made to repairing the roof of this property, but then explicitly took a neutral position and said, I don't mind which is the right one. You tell me, Judge, I'm not choosing. And the defendant said, well, I'm not choosing either. I'm not engaging with this game. And so the court was faced with a position where no party was actually making a positive assertion as to what the right decision was. There was also an additional point that actually the obligation was just an obligation to repair successfully, not an obligation to take certain steps. But that's nothing like this case, because as my lords and my lady have seen, we say what the Frand terms are, that's our licence. We have a clear positive position, and I'm anticipating that my learned friend Mr. Segan and Mr. Pickford will be saying that their licence is the Frand one. But certainly my clients will be advancing a clear positive case. Necessary and proper party, we've touched on this in our written submissions very briefly in opening. If there is jurisdiction at Mr. Pickford but not against Mr. Segan for some reason, we would rely upon that. Gateway 4A doesn't arise. I can't see any basis that arises. Now, that takes us to reasonable prospects of success. I'm aware of the time. I would beg 5 more minutes from my lord and my lady.
Yes, I think so.
Mr. Segan made 2 points. He justiciability, which I've addressed. He also maintains his submission that it must be a legal right, public or private. And he refers in particular to paragraph 74 of the ABVI decision. And he said that this does not support the proposition that to quote him, the only test is useful purpose. Sorry, I said ABVI there, I meant Pfizer decision. But actually, in paragraph 86 of the decision, my Birss said, in rejecting my then client Roche's submission, it said that is not right, because the only relevant limitation is concerned with useful purpose. And when the discussion in paragraph 74, my learned friend refers to, is in the context of some cases where there were extant UK rights. But as I showed my lord and my lady in opening, my Lord Justice Birss also considered the first instance Fujifilm and ABVI decision of Mr. Justice Henry Carr, where there were no rights in issue. I've addressed TQ Delta already, but I would just respectfully remind my lords and my lady about paragraphs 37 and 38, which reaffirm the standard approach which applies in the circumstances where an implementer does want a license. TQ Delta is an odd and extreme case. In my submission, it really does turn on the facts that there was, on the facts of that case, no useful purpose. On the question of forum, there's one point I'd like to deal with, which is the timing point. My learned friend hasn't addressed my lords and my lady on the Mohammed decision, which I discussed with Lord Justice Birss yesterday. That decision is referred to in section 11.1.3 of the current White Book, in the last paragraph in that section. Now, I'm afraid I can't hand this up, but what it says is an application for an order setting aside, an application for an order setting aside an order for permission to serve out of jurisdiction, made, for example, on the grounds that England is not the forum convenience, has to be approached on the basis of circumstances existing when permission was given. And the order cannot be discharged simply because circumstances have changed. And then it says, unless further evidence throws a light on what should have been a relevant consideration at the time permission was given. And it cites, as it was Mr. Justice Hoffman, in ISC Technologies. There's then a parenthesis reference to NML Capital. And then it says, by contrast, an application for an order that proceedings be stayed made, for example, on forum non-convenience grounds, falls to be considered in light of all the circumstances existing at the time of the determination of. So that paragraph does draw the distinction that I was submitting came out in the Mohammed case. And this is important because he says I cannot rely upon the timings issue, as at least as regard tort. Sorry, I've mangled that completely. I say that's important because the German cases were brought later. And they are not something that can legitimately be had regards to. And he does say that the position may be different because I made an amendment and relied upon a new grounds, the tort grounds, in February. Permission was granted in February 2020. Now that, even then, was about 5 months before the German cases were launched. So I don't accept he's right even on that analysis, but even if that is correct, at the time the application to rely upon the patent tort head was granted, there were no German cases in existence. One text that is of interest to my Lord Justice Nugee, which is, it's our understanding about the overlap between the two pools. It's our understanding that it is Advance's position that we should seek any rebate from the MPEG LA pool, and that the rebate should reflect the MPEG LA license fee, less an administration fee, and then only a rebate in a proportion to reflect the pools in the MPEG LA pool, which do not overlap between the two. In other words, to gain a license for them, we have in effect to renounce the part of the license we already have with MPEG-LA. And they've said, you may recall that MPEG-LA charged 20 US cents per device, whereas the advanced number is $1.33 per 4K television. And it is said that the rebate lies in the region of 10 to 15 US dollar cents per device, and that's taken from their German pleadings. So that's their case, 10 to 15 US cents per device. Now, they haven't suggested they've asked MPEG-LA about that, but we'll leave them there. And lastly, the withdrawal agreement. I think we accept my learned friend, Mr. Pickford's analysis that Brussels continues to apply as against him. If there was a new claim, one would have to look at all the facts of the claim to work out whether it fell within the second limb of Article 67 of the withdrawal agreement or not. My lords, my lady, unless you have any further questions, then those are my submissions.
Mr. Pickford has his hand up.
My lord, if I may, there was one new legal proposition which Mr. Chaxwell advanced that he didn't advance in his opening submissions, which is it was based on Foley and Fisher, and it was to the effect that the test under Article 7.2 is whether there is a close connecting factor. It's all about proximity. My lord, that is addressed by Lord Hodge in the AMT Futures case at paragraphs 14 and 29. And Lord Hodge there says that in his view, it's necessary to distinguish between the terms of a derogating ground of jurisdiction on the one hand and the rationale or justification for the ground on the other, as it is the former which confers jurisdiction, not the latter. And then he goes on to examine just the submission that was made by Mr. Chaxfield at paragraph 29, and he dismisses it. Thank you. That was all.
Do either of my lords have any further questions? No. Well, thank you all very much. It won't surprise you to hear that we will reserve our judgments. We will almost certainly be handing them down remotely in accordance with current practice. We will circulate drafts beforehand in the usual way. As I'm sure you are all familiar, that is your opportunity to correct our typographical errors and any plain errors of fact. It's not an opportunity to re-argue any points we have decided. Thank you all very much. Is there anything else? No. Good day.